webinar today. Documents are like diamonds. They last forever. Because our lines are muted this morning, you will need to use the question and answer software to submit questions to ask our presenters. You will notice a question and answer area in the control panel. Type in your question in the white area and hit send. You could submit questions at any time throughout the webinar. We will try to get to them as we go, but if not, we will respond to them at the end of the webinar. At this time, I'd like to introduce our presenters. With us today is Susan Engel and Jennifer Mason. They are partners with the law firm of Mincer, Sarowitz, Zeres, Ledva, and Myers, which is a regional insurance defense firm. Susan has been practicing law for over 10 years and is out of the firm's Philadelphia office. Jennifer has been practicing law since 1994 and heads up the firm's Pittsburgh office and was responsible for establishing the firm's e-discovery group. Before beginning the presentation, I'd like to read the following disclaimer. These remarks and materials are not intended to provide legal advice, but are rather provided for informational purposes only. Should you require legal advice, please seek advice from counsel of your choosing. The views expressed are those of the individual speaker and are not to be attributed to Old Republic, Risk Management, Inc., or any of its affiliates. Welcome to today's webinar. Old Republic, as you know, is one of the country's strongest insurers and your conservative business partner. We strive to offer innovative solutions for our customers. We have high standards for customer care, and we are offering today's webinar to further our business goals of strengthening the relationship with each of you by providing new and innovative ways to identify risk management opportunities. Today's presentation is about the ever-increasing volume of electronic information and how you and your business can rein it in using appropriate document management techniques. As an insurer and risk underwriter, we have identified the lack of document management as one of the leading causes of increased litigation costs and business interruption at the time of litigation. What we would like to do today is offer you some ideas to help you create business solutions.
Hi, I'm Jennifer Mason, and we're going to be talking about this subject today in the context of some do's and don'ts. That is, what can your business do or what it should not do with respect to document management to try to aid with litigation costs, to try to aid with document management, and try to avoid some common errors. So, with that said, we're going to start out by talking about some of the don'ts. That is, some of the things you should try to avoid in your document management system. Many times, individuals, and I oftentimes talk about staff because a lot of my staff come up with some really innovative ways to try to improve the way they do things. And they will often, if they can't get things done, take things home with them. And there are problems with that. There are problems with that for the corporation as well as for litigation. So how does that happen? Well, in litigation, if someone takes a document from the business, puts it on a thumb drive or puts it on a CD and takes that home, and then modifies that document at home, puts it back on a thumb drive, the issue is whether the document that's been brought back and is now uploaded into the system is the same as the document that was taken home, and whether those changes have been recorded. As you can see from the picture I've put on the screen of the two girls that are mirror images of one another, but yet there's one that's slightly a different color. It's kind of meant to represent that concept, that really they're not the same document. They really have differences in them. And when we go to do litigation, this can be problematic because we need to make sure in certain litigation that every form of the document is preserved. So it can be a very difficult thing to have those circumstances occur at home and for people to take information home with them. Susan's here with me, and she's going to discuss this with you a little bit.
And this is something that I've seen a lot in my practice, in that when the case first comes in and you talk to the client about what types of documents they have, and initially they'll tell you, I've got my work computer and everything is there, but then you start to explore the idea with them, and you start to ask them, do you do this work at home? Do you ever create documents at home or work on documents at home? And they say, yes, I do. And it's something that people don't always appreciate if they're not if they don't have this e-discovery background. They may not necessarily know that it's important to have all of those. So I know we'll talk more about it later, but it's something to really keep in mind as far as a policy perspective goes. If you can somehow create a policy where your employees understand that to the extent they're doing this work at home, they need to get it back onto your server, your computer, whatever it might be, back in the office, because although sometimes it's virtually meaningless in the course of litigation, sometimes it can be imperative and very important. So it's just something, it's a good habit to get into, and most people don't even realize that it's an issue. But the idea of people working at home and doing these things at home is very widespread.
So next, let's talk a little bit about the next issue, and that is text messaging. I want to talk about this because text messaging can oftentimes be a problem in litigation because it goes away so quickly and easily without the user doing anything. Most cell phone companies have a rule that text messages won't be kept longer than 30 days, and once they're deleted, they're gone. And so a lot of people use them these days for communicating with each other and certainly communicating about cases, and therefore there are preservation requirements. The case that you can see on your computer is actually a real case that happened, and that is that in terms of the police officer, he worked for a squad, and they gave him a cell phone, and when they worked on that cell phone, he actually was using it to personally send text messages to his girlfriend. And here's what he said. What happened in the business context was that the police force was trying to figure out why they had too many minutes or characters used and why they were being charged so much. So they wanted to look into the text messages and figure out why is it that this problem is arising. The question was whether they could really do that, because in the law there is such thing as privacy rights. And this is a public context versus private enterprise context. So we're first going to talk about public. One of the issues is with public information, should an individual who's an employee have a right to privacy in that information? The court in this case said, well, where a search is motivated by legitimate work-related purpose and it's not excessive in scope, we're going to allow it to happen. So in other words, this guy was mad because he didn't want people to see his text messages to his girlfriend. He was trying to protect those text messages, and they wanted to be able to see them, so the court said that they could. The next context is in the private context, and that is in a private corporation. Can a corporation look at the emails of its employees? And the answer is it depends. You can see in this New Jersey case that the court decided that there were some factors that they would look at to see if they could determine whether an employee had an expectation of privacy in their emails. And one of those things is to look to see whether the corporation has a policy banning personal use, whether the company monitors the use of personal email or of email in the company. Do third parties have a right to access the computer or emails, and did the corporation notify employees, or was the employee aware of the use and monitoring policies? These things were all important in determining whether the employee had a privacy interest in those emails. So really important to know, because a lot of employers say, well, these are my emails. Of course I can look at them. They're on my server. The answer is that may not be true. Susan, have you seen this come up?
I have, and I see it primarily in the employment law setting. You'll have employees that are problem employees that possibly the employer is thinking about terminating. The emails that the employee sends can be very helpful in defending a future claim if there's a discrimination, harassment claim, anything like that. But it's really important for the employer to have policies in place that make it clear to the employees that it's not their computer, it's the company's computer, and the company has the right to look at those emails, and they're not supposed to be using the work computers for personal use, policies along those lines, because later on you don't want to run into a problem where you can't use potentially valuable evidence because you didn't have these policies. It's one of those things where, an ounce of prevention is worth is that what it is? Pound of cure.
That's right. That's right.
So.
The question has arisen, and I'm going to read it to you. What happens to the hardware on my phone, my cell phone, if I get a new one? And my guess is the context this came up in is, hey, wait a minute, I didn't realize my personal cell phone was going to be potentially relevant. Maybe I want to get a new one before somebody finds out what's on there. And the answer is that it depends. If you give the cell phone back to the cell phone company, it likely will be wiped. On the other hand, a lot of people keep those cell phones, and that data will stay there. A lot of times the company will transfer some of the information over, but it will be based upon a time frame. So you really need to find out from your carrier what will happen. And if there has been a claim and your cell phone contains data that is potentially relevant to it, and you're on notice of that at that point in time, you need to make sure that that cell phone is preserved properly before anything happens with it.
And I think if I can just step in there and add on one thing, sometimes it'll be an individual, it's your client that may have the information on his or her cell phone. As soon as you know about the potential claim, whether it was as a result of an accident or some other sort of incident, let them, if they tell you, I've got phone records of this person calling me and harassing me, or I have photographs of what happened, or I took a video at the accident site and this person wasn't hurt, anything like that, you need to make it very clear to them that they need to preserve that evidence somehow, whether it is to pull that file off and get it to you for your file, whether it's for them to put that phone in a drawer and make sure that nothing happens to it. However you go about it, it's important to preserve that information, because otherwise it's going to be lost and you're not going to have that available to you as part of your defense.
And speaking of that, one of the most important things when you're preserving evidence is to make sure it's done forensically. That is so that it can be used later in a court of law. So you need to know if you're going to put that cell phone in a cabinet, whether the battery running out will result in data being deleted. Because if it is, you'll need to preserve it in a different way. And that's just one example. There are many issues. So you just need to make sure that whatever you do, the information is preserved properly. A good example is printing of emails. Is that okay? And the answer is it can be, but it probably isn't. Most of the time, printing of emails is not a way to properly preserve, because data needs to be preserved in the manner it's ordinarily maintained in the course of business, so that it can be authenticated. So really important to know how information is being preserved. I want to turn now to a case in West Virginia, and I mention this one really because it's very interesting. Cases go all over the board on whether information should be considered private. In this circumstance, it was a Supreme Court justice for the state of West Virginia, and he was having communication with a gentleman who was the leader of a business, and that business ended up getting sued. He, that is the justice, went on vacation paid for by the guy to Morocco, and the parties asked for him to recuse himself, or at least the defendant in the case asked for him to recuse himself back. The other justices, his buddies on the Supreme Court, decided that that, in fact, was going to be privileged information, which I find to be interesting and probably an outlier, because, needless to say, there was probably an interest in getting those emails. Let's talk more about emails. In sending emails, the question that I want to ask you is, a lot of people send email, and a lot of people send things in email that they wouldn't otherwise put on the letterhead of the company. And they do it because they're more familiar with it, they think it's less formalized, and they think that it just goes away. But the truth of the matter is that email is stored in so many different locations that when you are preserving it, you have not to just look at one place, but there are many places. So for example, if you send an email from your phone, it likely is also on a server, it's likely also on a backup, and if it's not in one location, if your cell phone's gone, you might also have to look at those other two locations to make sure of whether it is. Further, on cell phones, some cell phones will delete email when you delete them when you're sitting at your office. So if you delete it at your office, it also deletes it from your cell phone. But you can change that. So sometimes people have information on their cell phones that isn't otherwise on their computer at work. So really important to look at each of those issues. The context of the emails is also important, and what you say and don't say can be critical. So making sure that you treat email like any other communication is really important to consider. Susan, what are your thoughts?
Yeah, I always say, Jennifer says, don't send it if you wouldn't want your grandmother to see it. I always say, if you don't want to be confronted with it on cross-examination, then don't send it. You know, people, it's human nature, especially with the familiarity you have with others, to sort of vent or to say something. It might be an inside joke among, you know, clients or colleagues or things like that. But once you send that email, it's not going away, and it could come back to haunt you. So, you know, think about what you're sending, and if you really want to vent, which I find a very important part of my day at least, get up and walk down the hallway to talk to your colleague. Don't send it in an email. Pick up the phone and say something, but don't send it in an email, because even if the content of that email is something that you can explain away, you never want to be in the position of explaining something away to a jury, because they might not want to hear it. They might think you're protesting too much. Whatever the case may be, it's better to just not have it out there to have to explain away in the first instance.
Now, this is a mistake that's really common, and I point out this case because, you know, even the big dogs, even the people at AOL and Microsoft can make these type of mistakes. And in this situation in 1997, the government in its antitrust lawsuit against Microsoft obtained an internal memo from AOL, an AOL executive. And that memo said, "We met with Bill Gates. He said, 'This is your lucky day. How much do we need to pay you to screw Netscape?'" Well, the question that I have for you is that something that they would have put on their letterhead? Is that something they would want in front of a jury? And the answer is no. I mean, people write things in email and memos that they wouldn't otherwise write as communication. So my hope in communicating this to you today is to let you think about the way that you, your clients, others communicate with each other, so that in fact you are having much more defined ways of communication and organized ways of communication, so that information comes across in the manner you would have wanted to intend it. Next, social media. You know, people put information on social media, and they think that it's private. They think, well, only my friends are going to see this. But they don't understand privacy settings, and they don't understand that friends of friends can sometimes see things. And so it really is incredible the amount of information and pictures and what have you that individuals put on their social media accounts. Let's talk about some examples. An employee puts, "I'm taking off work tomorrow. My employer wouldn't let me take PTO. Guess I'll have to say I'm sick. Here's a picture of me in the winning shot yesterday." I mean, you know, in an employment context and in an employment suit where the employee files for wrongful termination after this happens, this kind of information is really important, but people don't realize that people have access to it. Susan, have you seen this in any context?
I do. I see it a lot. I mean, it can be a gold mine as a defense attorney handling employment cases, because people, they think that it's private, and it's really not. It's you know, it's something that people really need to be cognizant about. But yeah, I have seen it. I've seen it come up in all kinds of personal injury cases as well, where, you know, someone tells you in their case that they're horribly injured, and yet they're out snowboarding or building a new beach house or something along those lines. So people don't realize that, you know, just because they think their privacy settings are protecting them, they don't necessarily.
The other is that the protection of the corporate identity is important, and corporations and companies ought to have rules with regard to what their employees put out there. Now, this is certainly important in the context of attorneys and not advertising certain things or making certain claims about their effectiveness, but it also comes up in the context of other corporations, and that is that individuals employees will go on their social media sites and put information about the company. So the real important thing for a corporation to do is to set forth a policy of how its employees should handle it in their social media. And there are all kinds of these policies out there on the internet, some better than others. But if you need help with any of that, feel free to give me an email, and I'll shoot you off some examples, because getting a handle on your documents, where information resides and how it resides, is really important. So let's talk about it. We're going to go back just a hair and talk a little bit more about the home computer setting, because this is something that happens all the time. And I don't say it in the context of it being a bad thing. I mean, employees wanting to be more efficient and saying, hey, you know, I can get some more done at home, isn't a bad thing. I mean, you know, employees having the desire to do a better job is really a good thing. So, you know, we don't want to stop that. But the idea is that you need to know as a business, whether it's a claims handler or whether it's an underwriter or whether it's an attorney or whether it's the leader of a business, you need to know where your documents are. Because at the time of litigation, you need to make sure you can preserve them. So what are some issues that arise when people take their information home, and how can you get a handle on those things so that you make sure at the time litigation happens you can preserve them properly? One is to know that on a home computer, you know, businesses like insurance companies or mortgage companies or big corporations have a lot of security settings, encryption and that type of thing on their computer systems to protect them. At home, most often we don't have those robust systems to protect our information. So let's say as an attorney I take home a document that my client has provided me, and it is a privileged document. It contains trade secrets. I load it up onto my computer at home, and now my wife uses the computer, my husband uses the computer, my kids use the computer, their friends come to my house and they use the computer. That's an issue. And then in addition to that, other people try to hack into my system all the time with those crazy emails that they send around trying to get you to give them information. And so the last thing you want is your information to be in a location that you didn't know where it was, or for people to have access to your information that shouldn't have access. The other is that when people take things home, they might do something like on a Word document like cut and paste. That can change the data behind the data. So for example, with a Word document, if you hit copy and paste, it will change the date it was created. Now, if you're dealing with, let's say, a trade secret case or a patent case, that might be very, very important to you, because an employee taking trade secrets to another company and the date that happened might be evidence of the fact that they did it with a specific intent. And so that information might be really relevant to that case. It isn't always, but it's very important to know that it can happen, and that is without the user ever doing anything to make that change. The user may not even know that they've changed that data. So really important to know about your data and where it's stored and how it's created, so you know whether those fields can be relied upon. Susan, have you seen any of this happen?
I've seen not so much with respect to the copying and pasting or changing metadata, but I do see it a lot that, you know, like I said, people initially say, oh, it's just my work computer, but then you probe a little bit deeper and you learn that they are taking these documents home, and they you know, they may not be taking steps necessary to make sure that all of the information makes it back to the employer system in the first place. And I think it's worth noting that, you know, as a cost-saving measure, it's really a good idea to encourage clients to put these policies in place and maybe do some training with their employees to, you know, explain to them why it's important, how to do it correctly, because even though it may be a small investment, you know, up front, down the road, it might be a big cost savings when it comes to preservation and searching and things like that. If it's a known element that you're dealing with, then you know, it reduces the cost later on.
And let's talk about that, because that's the next thing that happens. Once an employee does this, that is, creates another location for data, what are you going to see from the lawyer involved in the case? And that is this litigation hold. This is a piece of the litigation hold that I send. But if you make additional information relevant and additional media sources relevant, then I may ask you at the time of litigation to preserve them. And I can tell you that individuals just simply don't like it when their personal computers become relevant to a case, whether that be their home computer, their cell phone, or any other source, because they have private information on it. So having a handle on where documents reside is really important, not only for that, but also for preservation purposes, because if that person had information on their computer and you didn't know about it, and at the time litigation happens, you didn't tell them to preserve it, and it's asked for by the other side and now it's not available, sanctions can be issued, and that's the problem. Let's talk about, interesting text messages, because, again, if you wouldn't put it on your company letterhead, don't send it. But one of the things you need to think about when you're sending any letter or text message is that if you're angry when you're sending it, it doesn't come across often in the way you intend it in a text message or email, or sometimes even a letter. So if you're angry when you're preparing something, you should wait 24 hours before sending it, because anger leads to problems. Using business and email or text to send personal email or text messaging, why should you avoid that? One of the reasons that commonly happens is that when people are emailing or text messaging with each other, they feel a much greater kinship or friendship or closeness to the people that they're sending it. They don't feel like it's as formal as a letter on letterhead. And so because of that, the information comes across in a different way. And what I'm trying to say to you to do is to start thinking about these very easy, breezy text messages and emails, just like you would something that's on your letterhead. Because if you do, then you will write things in a manner that you would intend them to be seen by a jury or in the context of litigation. Now, if you end up sending things to friends on your business email, it can also be problematic, because then you may result in your friends becoming relevant. And I'm sure they're not going to particularly like that. Further, you need to keep in mind that your boss might see it. Susan, have you seen circumstances where people, we had to go in and get additional media from people that we wouldn't otherwise have had to get?
I have seen it, and it's not only onerous and people hate you for doing it, but it becomes a huge expense. It's just something that it's easily avoided, and it's a really good practice to get into, because otherwise, it develops problems.
Now let's talk about a specific issue, and this is very specific to Facebook and other friending kind of situations. One thing you need to know when you're out there looking for information from the other side is that there oftentimes is some type of social media that those individuals might use. And if they use social media, you certainly want to try to get as much of it as you can. However, you have to do so in a way that is proper. And one of the ways, if a party is represented that is not proper, is to friend them. So you need to think of it in the context of, if a person or a party is represented by counsel, would I be permitted to go to their house and talk to them without their lawyer present? If the answer to that question is no, then you shouldn't do it. And so get all the information you possibly can that's public, but simply make sure you are not dealing with a situation where you've exceeded the bounds that you need to follow.
And that's true, not just you as an individual friending that person, but you can't have someone do it on your behalf at your instruction. You can't get around it that way. When you are putting information on social media, so let's turn from the issue of trying to get somebody else's social media. Now we're talking about dealing with documents with employees or with the corporation itself. You need to remember that information on media, even though you've got privacy settings, can often be viewed or shared by others. So you need to make sure that you are aware of this, that your employer is aware of this, and that you have a policy related to it. The other thing to remember is that information on the web just doesn't go away. For example, a lot of people don't realize that on Facebook, there's now a button that you can push that you can get every post onto your Facebook account from time immemorial, from the time you open the account. And so if you think, oh, 2 years has gone by, I'm safe, the answer is you're probably not.
Otherwise, it can also be used as character evidence. I mean, let's say you take pictures of yourself at some fun party at the beach, and you load them up onto your Facebook account, and they show you gambling and doing drugs and what have you, or at least drugs in the area. You know, that information might be admitted as evidence of character evidence in a case, so you need to be concerned about what you put onto Facebook. What to avoid in terms of email? One of the things I want to talk about now is the different types of searching that are done when I go to look for a client's information, because it makes a difference. I look by either using keywords or concept searching, but all of that really looks at words, or things like predictive coding. They're new methods of search that look at all of the words in the documents and to whom and from they're sent. But all of them rely on words. And if, in fact, you are using words like crisis, illegal, defective, covert, attack, scheme, shortcut, all those kind of things, inflammatory terms, those are things that may very well lead to something coming up as relevant and problematic. And so, you know, if you're thinking about writing something like, let's meet on Thursday to figure out how to defeat this claim, an email you might not want to have come up later in the context of a bad faith case, you instead might want to say, we'll meet on Thursday to evaluate this file. And those are much better ways to handle it. Words are important, and attorneys will try to make something out of whatever it is that you put in writing. So it's really important to focus on how you say something. You should consider email just like your letterhead. If you wouldn't show it to your grandmother or put it in front of a jury, don't send it. Now, I want to move now to something that I think is even more important, and this is document management in the context of email. A lot of time, especially if people have several claims or cases or suits together, they will combine information on those 2 things or 3 things or 5 things into one email. And it makes it much more difficult to sort that data, to find that data, and then to produce that data. So we're talking expense here. The point is that when you are dealing with your corporations or your clients or in your own business, you should organize your email just as if you were sending a letter. So you wouldn't send 2 letters on the same letterhead. Don't send 2 emails on the same letterhead. Do each email separately, because then it will be filed hopefully properly. Hopefully there's a system for preserving that email, and it will make its way to the proper file. I also recommend to people to use their in-ray lines to make sure that that's happening. So you're organizing your data by a file name, by a file number, by a claim number, because those are searchable things that are easy to find. And if I can find them, the cost is going to be a lot reduced. Cost is huge in e-discovery, and anything you can do to organize your data, reduce that cost, is helpful.
And even if you're not the one that originated the email, but if someone is getting back to you, and while they're on that topic, they say, okay, well, here's the information you asked for in the Smith case. What's happening in Jones? Another case. If you're the recipient of it, I mean, you can't control what they do to a large extent anyway, but you can certainly break it out into 2 emails, or to forward it and change the ray line to reflect the new matter number that you're discussing. So at least you can get it saved properly, and you can see where it originated. So even if you're not the one that's doing it, there are steps that you can take to control those documents and make it easier to manage later on if it's necessary to do so.
Again, never forget, documents are like diamonds. They last forever. So let's talk about now some of the things that you need to think about doing in your companies or corporations or offices. One of the issues that you need to consider is, when I am dealing with a case or a claim or whatever, when is it that I need to do something to make sure that I'm protected? That is, when do I need to make sure I preserve? And the answer is when you are reasonably on notice of litigation. It doesn't have to be when the case is filed. In fact, it doesn't even have to be a claimant calling and saying, I'm filing a claim. It can be as early as an event happening or even before that. If a plaintiff corporation is going to file suit against somebody else, they may choose to file that suit or make the choice to file that suit long before the suit is ever filed. And so it's when that choice becomes readily apparent. So really important to know that once you're reasonably on notice that litigation will be filed, you need to preserve. Other things that you need to, and by the way, this is a chart that I put in here. We're not going to go over every one of them. These are some of the states in which I practice, but it talks about this whole concept of the duty to preserve and when it arises. So I've given it to you for a case. If you need other states, just let me know. But as you can see from the notes, a lot of them are very similar. That is when a party reasonably anticipates litigation. What happens if you don't preserve? That is, once you're on notice of a case, if you don't preserve information related to the case, what can happen? And that is sanctions. And they're all over the board. They can be anything from doing additional discovery to issue preclusion to a motion for summary judgment. So it's really important to know when you are on notice to preserve. And that for attorneys, it's really important because, you know, Susan and I get the cases, you know, usually about 2 years after they're filed. We have no ability, therefore, to tell the client that they need to preserve or what should be preserved. Each of you guys may be in a better position to do that. And so what you need to know is that that duty arises when they're on notice, and oftentimes that has to happen before an outside lawyer is involved. So, you know, just making sure you know that oftentimes you're not going to be able to rely on your outside counsel to make sure that the preservation is done properly. And if you need our help with doing it, we certainly can. And
it's, I mean, you know, if you're talking about something like a major construction accident with major injuries, I would suggest that, you know, there are courts out there that would find that you're on notice of a potential claim the minute that the accident happens. I mean, it's you know, something that you can certainly reasonably anticipate. So, you know, it's better to err on the side of caution and put the hold in place than to regret it later.
And what I'm looking at now is the slides on state court rules. And again, I've given you the ones, the jurisdictions in which I practice, because different states have different rules, and they're very different than the federal rules. For example, Pennsylvania has specific e-discovery rules, and they focus much more on proportionality. Now, the new proposed e-discovery rules with the federal court are changing, and in fact, relevance, the definition of relevance is changing in the new rules to include proportionality. But those probably won't go into effect until December of 2015. In the meantime, you need to know that's out there. Is preservation expensive? It doesn't have to be. I mean, preservation can be putting something in a filing cabinet like a backup tape. But you need to make sure you do things properly. It depends on the type of case and the volume of data and where it's stored about how to do it properly. So you need to make sure you know what you're doing, because, again, printing of emails, a lot of people think, oh, if I print these emails that are relevant, it'll be okay. Or, hey, I've got a file on this case, and so I know that's what's relevant, and that's what they put into their filing cabinet. But you need to understand that information beyond that can be relevant. So, for example, the employee file of an employee who was involved in the accident might be relevant. Certainly with punitive damages, financial information might be relevant. Training might be relevant. Policies, practices, and protocols of the company might be relevant. I mean, it goes on and on. And so when you're thinking about preservation, it can't just be in a vacuum. You need to make sure that you're preserving anything that could be relevant to a claim or defense of any party to the litigation. And sometimes that can be more broad. So understanding preservation is important. And then once you understand what you need to preserve, knowing proper techniques to do so as inexpensively and efficiently as possible is also important.
And again, having those policies in place and explaining to employees what they need to do to manage the documents in the first place can cut down on the cost. I can't stress enough how much more it is if you have documents spread everywhere, and you know there's no subject line in any of the emails, and some of them are on somebody's home computer and some are on a laptop. I mean, it just exponentially increases when it doesn't have to. So again, getting employees to get a handle on it in the first instance can really be helpful.
And here are some of the ideas that you know are out there that in terms of trying to get a handle on your data. I mean, one is to create a document retention policy, identifying what documents are important to your business and where are you going to store them and how are you going to store them. and how long are you going to store them? Because one of the important things with document retention is, when can I get rid of this? So businesses really need to get a handle on their documents, what's created, and when they can get rid of them. Then you need to create a reasonable process to preserve that information when litigation arises, and to stop the document retention policy, that is the destruction of documents, when you're on notice of litigation. So all of it really has to do with individuals and corporations getting a handle on what data they have and where they store it. Another is, once litigation is involved, that you guys have a handle on the attorneys who are handling things for you. And that is that you don't let them bicker with one another over things that really aren't necessary. So that you really understand the e-discovery process. And look, these people are fighting over things just to file motions and send me a bill. And really what they should be doing is sitting down and cooperating with one another. And there's some good articles about that at the Sedona Conference. It's called the SedonaConference.com, and the Cooperation Proclamation discusses various things parties should be cooperating about under the rules, trying to get down to the bottom line of, what can we share with each other to try to make things less expensive rather than more expensive.
And Jennifer and I have had great success in cases when, we'll get the case and we'll get a set of document requests, and they're usually fairly inartful. They're grossly overbroad. And instead of, sitting down and writing out objections to 78 document requests, we'll set up a conference call, we'll call the other side, and we'll say, what is it that you want? Don't tell me 78 different things. Give me a sense of what it is that you need. And let's talk about how we can do it without spending tens of thousands of dollars. And we've actually had a case or two where, after we had that conversation, we actually didn't even engage in any e-discovery, because it turned out that all of these things that the other party would potentially like to have just didn't exist. So it's something that, it doesn't work in every, circumstance, whether it's the type of information that exists or the personality on the other side. There could be a number of things that don't make it work that well, but a lot of times it does work that well, and it's a good thing to encourage counsel to do, instead of, the knee-jerk reaction to fight all the time and file motions and object. Let's sit down and figure it out, because at the end of the day, everybody just wants the evidence that's relevant to the case.
So one of the questions that arises in preservation is oftentimes, what do I have to preserve? Is it just stuff that I have in my possession? And the answer to that question is no. You need to preserve anything that is in your possession, custody, or control. And I just put this in here because I want people to think about e-discovery a little more broadly than they tend to. And that is that, bank accounts can be included, attorney files, third-party host of your data, others you hire to do part of your work. If you have custody or control of that data, you may also have to turn it over, and you need to make sure, in the context of your case, that you identify those other third parties. A good example is like in a pharmacy litigation case dealing with labeling. You may have somebody that you send information to about how to print or change your label, and they may store that data longer than you do. And if you don't have it, but they do, you need to make sure you get it. So that's just a good example of one of those circumstances. How can I acquire the plaintiff's email, blogs, text, or social media? I want to point you here to a resource, and that is the Stored Communications Act, because there are exceptions to the Act. I mean, the Act really is talking about what's private, but under 2701C1, there are some exceptions, and that is if the person or entity providing a wire or electronic communication service authorizes you to get that information. In other words, a court may require them to provide a release for that information, so you should be aware of that. Third-party subpoenas. Oftentimes I get calls from my carriers saying, I have a client here who got a third-party subpoena for e-discovery. Do I have to answer it? And the answer is that you do. It's very important to know the rules related to it, because oftentimes you can try to cost shift that. In addition to that, the limitations in scope on third-party subpoenas, they certainly have to be more proportional, and I find them to be much less burdensome according to courts than subpoenas to parties. So it's really important to know the rules and know how they're put into place. But if your entity, let's say, for example, if in the employment context and there's an employee who is injured at work, and there are several other contractors on the job that your employee was working on, and the employee is injured. Oftentimes that employee is going to sue those other entities and they can't sue their employer. However, the employer has a lot of data that's relevant to the case. And so they need to preserve and they need to potentially produce that information. So, they need to be aware of it as well. Text messaging, what can you do? One of the things that you need to know about text messaging is you've got to get it early and you've got to get it quickly. Usually 2 years later, it's not going to be there. So when you are looking at text messaging, if you're talking to people and they tell you that text messages were done and are relevant to this case, get them early and get them properly. I can't emphasize that enough. How to get email, blogs, texts, or social media. Again, this is referring to that Stored Communications Act, and if you need an authorization, I have an authorization, and you can just send me an email and request it. Is social media always discoverable? In my experience, no. And I've listed some cases here that I've cited before that go both ways. Some courts look at different issues with respect to them. One is, have the parties had a chance to get in the information otherwise? One is the information private, and is there a reasonable expectation of privacy? But you really ought to look at your particular jurisdiction to see if you can always get at Facebook, because a lot of people now change their form discovery to include it, but it's not always discoverable. And if you ask for it early and you don't have your things lined up, you may not be able to seek it. So you need to make sure that you set a good foundation in your particular jurisdiction for being able to acquire it by way of a discovery request. Susan, have you dealt with any of that?
I know that there's all kinds of different opinions out there. I haven't actually litigated it in front of a court, but I know that other colleagues of mine have, and they've been, the other party has been ordered to provide the password so that they can see the post.
Let's talk a little bit about now the what else you should know, because in the context of e-discovery, there are all kinds of articles out there that talk about how expensive it is, and it can be. I mean, especially if people do not understand and know what they are doing, it can be a very expensive process. So it's important to have a handle on documents, to have good document management systems, and then it's also important to know how to do e-discovery properly, how to preserve properly, and then how to search and produce properly. Getting a handle on all of those issues will result in being able to handle things in a much more cost-effective manner. But it really starts with garbage in, garbage out. If you don't preserve properly, then you will not be able to search or produce properly. So that initial issue of preservation is critical, and remember, a lot of times you don't have outside counsel at that stage to help you. Next is that vendors aren't all alike. A lot of these vendors are going to be out there seeking your business. They're going to come around and they're going to say, we want to do all your work and we'll give it to you for a great price. But the problem is they're not all alike. And if you, put yourself in a situation where you've hired one vendor because they're going to give you a great price, you need to make sure you've vetted them. You need to make sure that you know whether they're able to identify the proper documents, whether their algorithms work properly, whether other people have had issues, whether there have been a lot of lawsuits or motions about their process. So really very important to vet those vendors and make sure that what they're promising is actually going to give you the results you need. Don't forget about things like GPS devices and things in cars. Don't forget in trucking cases about the mobile devices that follow the drivers. Another good one is that a lot of companies give drivers their credit cards and they use them at a gas station. Well, in my cases, what plaintiff's attorneys will do is they'll get the time of one stamp from one gas station, the time of the next stamp from the next gas station. They will figure out the distance using GPS between the two and figure out how fast it is that that truck was traveling over the course of that distance. So really important to make sure you're thinking about what are the possibilities out there that might exist. With restaurants and cases involving alcohol, the printout receipts of what from the bar tab of what people were drinking in the course of time over which they drank it. Important to know and important to make sure you preserve. There are also mobile devices now, you've probably seen the commercials about them, where individuals can send a claim directly to the claims adjuster right from their cell phone. Photographs on cell phones are often important, and videos on cell phones. So make sure you're not leaving information behind that might be of particular importance. I've listed here some future steps for you. I certainly want to give people some time to ask some questions, so I'm going to give these pretty quickly. But first, identify procedures to follow to assess the risk. One of the things I really highly recommend to companies that I've been pushing and talking to companies about for a while is that in risk management, in terms of underwriting, you should be talking with the companies about how they store data and whether they have a good handle on it. Because if they don't, it can greatly increase the cost of litigation. So think about that in the context of underwriting, because if corporations do not have a handle on their data at the time that they have litigation, you can have some huge expenses. Train your employees. Make sure they understand. If you have a policy and a procedure, they got to make sure they follow it. So make sure you train them how to follow it properly. We're going to go now to question and answers.
There aren't any additional questions or answers that have not been responded to. This is Judy. However, if anybody does have an additional question that they want answered, please feel free to either email Susan or Jennifer or myself, and we will make sure that it gets responded to. There is a question, however, if the presentation will be available. Yes, it is. You could email me at gotowebinar@orrm.com, and it will be sent to you without the clip art. And at this time, we'd like to thank everybody for attending the webinar. I'd also like to extend a special thanks for Sue and Jennifer for doing such a great job. This webinar was recorded, and it will be available on Old Republic Risk Management's website. I will send an email to everyone who attended that the broadcast is available. And again, if you do want the slides, just email. All right, there'll be a short survey that will be sent out. We'd greatly appreciate it if you would just take a few moments to complete it. We look forward to having you attend other webinars, and this will conclude the broadcast. Thank you very much.